We will start off with some basics about federalism. I know you guys are already somewhat familiar with federalism from the early part of the course when we looked at regime and government system types. So most of this will be review, a little bit of it will be new. Remember, federalism is the mama bear between the papa bear of a very powerful government, central government in a unitary system, and the baby bear of a very weak government, central government that is in a confederal system. And it is power sharing that lets federalism be the mama bear. And in terms of power sharing, at the root level, we're talking about the idea that citizens are under the authority of two different levels of government. And it's broadly the same type of authority. And so a citizen of Missouri is subject to the authority of the state of Missouri and also the national government, which of course we refer to as the federal government. And a lot of that authority is very much overlapping. We have national laws that affect some of the same behaviors and actions as state laws. And there's also a difference between the three systems in terms of intergovernmental relations. Now, intergovernmental relations is kind of this giant catch-all term. It could be any of the interactions between not only regional and national governments, for us, state and federal, but also your local governments, municipalities, townships, counties. To give it a little more specificity, to some extent we're talking about laws and regulations and how those can interact between the different levels. And one of the areas I think where we can kind of most clearly see this, to some extent we can actually quite literally see it, is in terms of environmental regulations. And kind of related to that, even like consumer regulations. So the federal government, for example, has laws about emission standards for cars and trucks. And states can sometimes have their own regulations on those same things. Now, when we have that kind of a situation, no state can have regulations that are less strict than the federal regulations. But what we see, especially in the case of California, is a tendency to have regulations about environmental protections that are much stronger than the federal standard. Which is why if you pull up alongside, or if a semi pulls up alongside you and you look at the actual truck part of that tractor trailer, somewhere probably around like the lower corner of the door, you will see a sticker in the outline of the shape of California that will say California Clean Idle Certified, because California's standards are much stricter than the federal standards for emissions from, in that case, semi-trucks. It's also the reason that on tons of stuff you would buy, even when it doesn't clearly make sense, you will see a P65 warning, and that is a warning that is mandated by California for goods sold in California that might somehow have a risk of causing cancer or birth defects or something like that, or reproductive harm, I guess is the other one. Right, that's not a federal requirement. That's a California requirement. The only reason we see it in the state of Missouri is that California is a huge state with tons of people that buy stuff. Another area we see it is in terms of funds transfers. And there's no reason that we can't be talking about local and state governments sending money to the national government. But what we will talk about, because this is, for all intents and purposes, the exclusive way that happens, is in terms of the federal government transferring money to states and local governments. And as we will see when we look at that in more depth, a lot of times that money comes with strings attached. in terms of things that state and local governments have to comply with in order to get the money. And the third is information sharing. And this can be really boring stuff. It might be sharing statistics, like economic statistics, for example. But it can be related to more controversial things. And we've seen this some with political disagreement and conflict over policy towards undocumented migrants, which clearly this could also connect to law and regulations. But what I'm thinking of here would be the development of so-called sanctuary cities. And so this has primarily been a local government phenomenon, which say they will not cooperate with federal law enforcement, right, to locate, detain, arrest, or deport undocumented migrants. Which means law enforcement might know where such people could be found, but they will not share that information with federal law enforcement. In these intergovernmental relations, one of the things that may seem like a minor detail, but is absolutely essential to setting federalism apart, is that the regional governments have the powers that they have as a result of the Constitution itself. It is not a creation by or a privilege from the national governments. The same Constitution that creates the national government tells us what the states are able to do, what will be their power in these intergovernmental relations. And that's important because, especially if you later take a comparative politics class, you will see in unitary states in recent decades, some of them have been doing something called devolution, which is where they devolve powers that belong to the central government to regional and local governments so that those regional and local governments can manage different policies. This has happened a lot in the United Kingdom, where power has been devolved from the central government in London to Scotland and Wales and Northern Ireland, and also, of course, England itself. A lot of that's been in terms of things like education and managing healthcare systems. But because that is not a constitutional arrangement, if the government in London wanted to take away those devolved powers, it could do so, and it could do so very quickly. In a federal system, that kind of power in the hands of the national government does not exist. Of course, we will be focusing on federalism in the United States, but to understand our system, and partly kind of what makes it special, is to understand it in terms of an international perspective. And the first thing there to note is federalism is rare as a system of government. Depending on how you define federalism or you measure its elements, somewhere between about 11 and 25 countries qualify as federal systems. And my personal take on that would be that the number is actually closer to 11, quite a bit closer to 11 than 25. Sometimes definitions count countries like Switzerland as federal, and I can kind of understand that, but it is still, to my mind, more of a confederal system, for example. Other counts might still consider Russia as a federal state, but we'll talk about that in a minute as to why it probably isn't something we should consider a federal state. Because it's so rare, there are no hard and fast rules about why some countries become federal systems. There are some tendencies. Large countries, and here I mean geographically large, not necessarily large in terms of population, are more likely to be federal systems. The United States, of course, being an example of a geographically large country with a federal system, But the same is true for Canada. And Canada kind of shows the point about this being a geographical feature rather than population. The United States has approaching 340 million people. Canada is approaching 40 million people. Both are federal systems in geographically large countries. Australia also fits this pattern. Large territory, but like Canada, a relatively small population. Other geographically large countries like China are unitary systems, and extremely unitary. Everyone in China, at least at some level, has to operate on Beijing time. Doesn't matter what time zone you would actually be in, you have to operate according to Beijing time. It's also more likely to be adopted in countries that have a lot of regional diversity. India is an example of this. Of course, India is also geographically large and has a large population, but it also has tremendous ethnic diversity, a lot of religious diversity. Sikhs, Hindus, Muslims, all in one country, three groups that often do not get along well with each other. Nigeria, not a large country geographically, has a large population. But again, here the key is regional diversity. In the north is the Muslim region of the country. The south is Christian and pre-colonial animist religions. They also have a lot of different languages spoken, and other kinds of cultural differences, ethnic differences. But if we think about it in terms of the religious diversity, in northern Nigeria, the state governments, actually I don't know that they're called states to be sure, but the regional governments enforce Sharia law, which Sharia law is Islamic law based on the Quran and Muslim teachings, whereas in the south, which again is more Christian and animist, the government does not enforce Sharia law. And so in that case, you have very different legal systems in different parts of the country. And then finally, Germany. Now, I put the question mark here for you, not for me. I can understand why students would question, like, what kind of diversity does Germany have? And most of the people there are ethnically German. If you are not ethnically German, even if you are born there and your family has been there for a very long time, it is hard to really be accepted as German. But there is a lot of regional diversity in Germany. Part of that is it's not that old a country. There was no Germany until 1871. Before that, you had a collection of different principalities and kingdoms, and it was all part of the Holy Roman Empire, not too long before it became a country. You also have Protestants in the north, more Catholic in the south. There are a lot of dialect differences in Germany that can make it hard for people from different parts of Germany to understand each other if they use just their everyday language. And so Germany, federal state, also fits that bill. Another thing to note, all federalist countries are democracies. The asterisk there is partly because we have, just even in this partial list, some countries that could become exceptions, right? Or they might cease to be federalist. In the case of India, it's become less democratic, especially if you look at like Freedom House measures of democracy, and seems to be moving farther away from democracy. Nigeria is trying to make democracy work. They've had a long history of military rule, but they have still lots of problems with corruption and difficulty in their elections. And then finally, countries like Russia. Russia is called the Russian Federation. In a lot of ways, on paper, it still looks like a federal system. But as Putin has become more dictatorial, he has increased the power of the central government and taken more and more power away from the regions. And so Russia is no longer a federal system, at least in practice. Now back to the United States, where we will be for the rest of the time we're talking about federalism. We are a federal system, but federalism does not appear anywhere explicitly in the Constitution. Instead, we have a federal system partly because it was created by strong states. Remember, the states are older than our Constitution. They got their start as separate British colonies. They got used to being strong states with a weak central government during the Articles of Confederation, and so states were strong and they were jealous of their powers. And they wanted to make sure the Constitution would not take them away. And that was part of the Federalist, anti-Federalist debate. Very much a part of that was also the fact that citizens' loyalties to their states were stronger in general than their loyalties to any national government, or really any notion of a United States as a country. To some extent, the importance of states is enshrined in the Constitution itself. And the strongest and clearest way this is done is in terms of representation of the states in the Senate. And remember, every state gets 2 senators. And Article 5, which is the article of the Constitution that explains the process for amending it, has a specific provision. It's not a long article, but in there is a specific provision that no amendment can reduce a state's equal representation in the Senate. The only exception being essentially something that will never happen. A state would have to consent to have its representation in the Senate reduced. And there might be some large states that would care less about the Senate, like California or Florida. But certainly smaller states like Wyoming or the Dakotas, Nebraska, they're not going to consent to having their number of senators reduced. Beyond that, the Constitution is really pretty vague on what powers states have. And that's not really a surprise. Remember, the Constitution was created out of an effort to fix what was wrong with the Articles of Confederation. So the Constitution specifically wants to do things like give the national government powers to tax, powers to regulate trade between the states, powers to make treaties with other countries, and make all of those powers exclusive to the national government. And as part of that, not only is it pretty specific about national powers, especially in Article 1, but Article 6 and its supremacy clause tell us that national law, including the Constitution, will be supreme to state law. And so will treaties. And because of the new powers that are exclusive to the national government, treaties can only be negotiated by the national government. So if the national government agrees to a treaty with a foreign country, whatever law comes out of that treaty will trump all state laws. States have tried to push back on this at various times over 200 years. Especially early on, this was through a concept called nullification. This was tried, for example, in 1798 against the Alien and Sedition Acts. It was tried again in the years up before the Civil War by southern states to try to get rid of federal laws that they didn't like. The idea, or at least the theory behind nullification, is that states have the power to interpret the constitutionality of laws. And if a state's government determines that a law is unconstitutional, they can nullify it, meaning it won't apply within their borders, and that state does not have to follow it. More recently, we've seen other cases. I mean, even in the 21st century, pushback against more government efforts to kind of control and make uniform how public school children are educated in this country, like No Child Left Behind. All of these efforts, whether, especially with nullification, have just been plainly unsuccessful. John C. Calhoun was the most famous of the nullifiers, and I mean, despite all of his arguments and all of his efforts, it just was not successful. And still in this same topic, the federal government has increased its power relative to the states over time. Some of that we can see in the previous presentations about a more active and larger federal government, especially larger executive branch. But that is kind of a phenomenon that begins in the 20th century. We can talk about increased federal power relative to the states much earlier. Coming out of the Civil War and Reconstruction, as one example, take the 14th Amendment, bless you, which has a lot of provisions, but for our purposes, what matters is its due process and equal protection provisions. What these provisions essentially say is that state governments cannot infringe on the rights of citizens, which doesn't sound like a shocking thing. But remember, the Bill of Rights that does specifically list rights that will be protected only applies to the federal government, at least as initially written. Because even the anti-federalists who were concerned about government power expected only to have to worry about violations of rights coming from the national government. The 14th Amendment begins a process of extending Bill of Rights protections to the state level. And that was, of course, a lot of that was to protect the freed slaves from being persecuted and having their rights violated by Southern governments after the war. Kind of still in that same theme, we have policies coming out of the Civil Rights era. Again, just as an example, as a result of the Supreme Court decision in Brown versus Board of Education, the federal government said states could not segregate public schools. And the federal government enforced this by calling up National Guard troops under federal authority and ordering them to ensure that integration took place. Later, when that ban on segregation was extended in practice to universities, U.S. Marshals enforced it after Governor Wallace in Alabama said he was not going to allow the integration to go forward and tried to personally block non-white students from entering the school. And more recently, federal fund transfers have become an important way for the federal government to have greater influence over the states. By attaching conditions or strings to the money. If you want the money as a state, there are certain policies you might have to adopt, or the federal government won't give you the money. Which is something we will have to look at in more detail later, but for now, that's enough to say. some of you are familiar with the 10th Amendment already, you might have been asking, well, where is the 10th Amendment in this story? It is there. And for those of you that are not familiar with the 10th Amendment, and so far, even though it is the final amendment in the Bill of Rights, we haven't really talked about it, because it's the one thing that does not apply to individuals. It is, if somebody's ever putting together a cheat sheet of the amendments, the 10th Amendment is the Reserved Powers Amendment. It says that powers not delegated to the federal government, so powers like the power to declare war or coin money, so powers that are not included in that list and are not prohibited to the states by the Constitution are reserved to the states. The problem with that has been it's fairly imprecise, is to really know what powers that leaves to the states. And we would hope then maybe in that case that the Supreme Court would kind of iron things out and provide a clearer understanding of what the 10th Amendment does not or does do in terms of the state's powers. Unfortunately, the Supreme Court has contradicted itself over time. In 1941, U.S. versus Darby, the Supreme Court opinion in that case essentially said that the 10th Amendment was just a declaratory statement. It said states have powers, which essentially is just an acknowledgement of the facts on the grounds. States did have governments, those governments had powers. The Supreme Court said acknowledging that the states have powers does not in any way put those powers above the powers of the national government. And this is not a constitutional law class, and if it was, I wouldn't be qualified to teach it. But essentially what that ruling seems to do is just kind of reiterate that, yes, there is a 10th Amendment, but there's also an Article 6 in the Constitution that says national laws are supreme. In 1976, in the decision in National League of Cities versus Usury, the courts kind of handed a victory to the states. They said that national laws imposing maximum hours and minimum wage standards on the state were an unconstitutional intrusion on state prerogatives. But for those of you that have jobs, you're probably already aware that something happened because there is a federal minimum wage. States can have minimum wages that are higher, but they can't have any that are lower. That's going to be connected to a decision that came less than a decade later. In Garcia versus San Antonio Metro, and the court's ruling overturned that. Skip ahead to 2011 in Bond versus United States. The Supreme Court does make a mention of the 10th Amendment and the possibility that the federal government could overstep the 10th Amendment with federal law. But this is kind of a strange one because it specifically says that a citizen charged with a federal crime. And in this situation, think of a citizen who is doing something that according to their state's law is legal, but according to federal law is illegal. So if such a citizen is charged with a federal crime, they can challenge the charge by arguing in court that the federal law violates the 10th Amendment and is therefore unconstitutional. So that we don't interpret this as a big win for the states, the key really is that we're talking about citizens. A citizen who has standing in court because their rights might be harmed by this federal criminal law are the only people that can bring those cases. States cannot challenge a federal law according to this opinion. It would have to be a citizen of a state. And that is where we are going to stop. You'll have the remainder of the class to continue work on the homework assignment from yesterday. So this is a good opportunity to work with the people at your group of desks on that assignment. Remember, outside of class, I would also encourage you to form informal groups to work on this, but please make good use of this time that we've got before the end of class.